Okay, so our case was about Media News Group Inc., who was the defendant, and Kearns Tribune LLC, which was the plaintiff. The court was the United States Courts of Appeals, the 10th Circuit. Some of the history was January 2001, AT&T sells the Tribune to Media News for $200 million. The Salt Lake Tribune Publishing Company, which was a newly formed business under the previous contract, took this issue to court to seek an injunction to block the sale of the Tribune. Also, district court gave the purchasing rights to the Salt Lake Tribune Publishing Company. In November 2001, they were challenging the family agreement. The family agreement was the agreement reached by all hires as to how an estate should be distributed. They used this appeal to enforce the collateral stand contract, which was a 5-year deal. It said that Tribune will be returned to the family after 5 years. They also argued that oral agreements should be covered under this policy. The court found that the Statute of Frauds Act as an independent bar to its family agreement enforcement. Then in 2006, the Tribune was appraised by both parties. Salt Lake Tribune Publishing Company, also SLTPC, got $218 million. Media News, $380 million. Management Planning, which is a third party, got $355.5 million. And that was the final valuation. SLTPC brought on a lawsuit to challenge the official valuation of the Tribune, and also has been brought to the court twice on appeal and is still pending to this day. Now I'm going to pass it on to Matt.
Alrighty. So as you can tell, Media News Group Incorporated versus McCarthy is a little bit of a complicated case. They had obviously a few valuations that were different from each other. But the legal question here is that does the McCarthy family have the legal ground to sue Media News Group for the breach of contract? And this, and additionally, does the statute of frauds apply to any of these contracts that were made between the two parties? So the rule of law here deals directly with the statute of frauds. And what the statute of frauds does is it governs which contracts must be in writing and if certain contracts can be enforceable through oral agreements. So kind of the key concept of the statute of frauds is that not all of the contracts have to be in writing. These can be oral agreements, but there are a few terms and things that can determine whether that's enforceable or not. So specifically, some of the contracts that can be oral and can be enforceable are sale of interest in land contracts, contracts that cannot be performed in less than 1 year, contracts to pay the debt of another, marriage contracts, and sale of good contracts above $500. So the statute of frauds applies to the oral agreements that were made between the McCarthys and Media News Group, but the written agreement that they had actually supersedes the oral agreement. So, and on top of that, oral agreements are only valid through a 1-year term. So in this case, the statute of frauds actually would bar the enforcement of the oral agreement that the McCarthys had, in which they would be getting the Tribune back. So in this case, the McCarthys do not have the right to enforce that oral agreement, but everything that was in the written agreement that superseded that oral agreement would be applied to the case. So obviously they're still trying to fight this, but the court did rule that the statute of frauds bars the enforcement of the 5-year contract. So that's all.